The US and Mexico have strong economic ties through the North American Free Trade Agreement. How has that affected Mexico's economy?
The NAFTA countries between United States, Canada, and Mexico have had a great improvements in their trading, in exports and imports. For instance, the income and revenues between the United States and Mexico in the last year has been around $40 billion, which is important, and it is expected to continue growing and developing.
And which industries within Mexico are particularly attractive to foreign investors, and why?
Well, Mexico in the last decade has been amended its legal frame in order to harmonize it with the NAFTA countries and with the developing countries of the rest of the world, having a very good place for doing business. So investors from all over the world coming to Mexico to invest in the major sectors of the economy: telecommunications, tourism, mining, all kinds of financial services. Actually, Mexico is a very attractive place of doing business. That's why foreign investment in Mexico has grown significantly in the last decade.
And in terms of the latest developments within the legal arena of insolvency and restructuring, which role has insolvency played in Mexico's revival from the global economic crisis?
Well, Mexican insolvency statute, namely Ley de Concursos Mercantiles, was enacted back in May 2000. Since then, there has been only 440 filings total, voluntary and involuntary, most of which 70% or 75% have been involuntary filings made by creditors. 440 filings total in more than a decade. So it shows that it doesn't work. This new law was purported to be a model for other countries, following the United Nations Legislative Guide for Insolvency Statutes, and to also incorporate the newest and best features and trends that the world has experienced in other latitudes. What happens? It failed. It failed. Unfortunately, the new law did not incorporate these trends and these features. Mexico is in real need to have a 21st century insolvency system to incorporate all the features for the sophistication of current financial situations. But the question is, what distressed companies or businesses do when they are facing insolvency? Well, they go for restructurings out of court of private transactions, or they have to face long and costly litigations, or sometimes they just try to put away assets from the reach of the creditors by transferring them under fraudulent transactions or conveyances them or hiding assets in general. We need to incorporate, just as an example, a insolvency protection even before the debtor incurs in insolvency. We need to provide for a group of companies discharge. Also, another feature that is currently under fight in litigation is the protection of bondholders, of bonding issuances. Vitro is a current case that is being under litigation. Vitro is a large Mexican company that owes around $2 million. And there were some issuance or bonds due on 2012, 2013, and 2017, which were not paid, even interest. But the interesting issue here is that Vitro, before applying for bankruptcy in Mexico, they executed a reorganization in the financial and corporate area of this group of companies. By means of this restructuring, Vitro created a new debt in favor of its subsidiaries, having the subsidiaries as creditors for $1.5 billion about. So with that amount, they control the majority of the creditors. Therefore, they imposed the plan of reorganization to the real, authentic creditors. This should not be allowed by the Mexican courts. US courts will not recognize this reorganization plan because it violates public policy of the United States. But that's a big problem because that causes a lot of security. So bondholders, creditors must have certainty. They need an efficient insolvency system. And as I said, there have been, in more than 10 years, 440 filings, of which more than 70% have been filed by creditors, of which less than 1% have reached the plan of reorganization. And we don't know yet how many have been succeeded, but very few.